Substantial question of law in this matter that concerns the interpretation of the Constitution to warrant the impaneling of three judge bench. This is a simple commercial dispute where the court appointed an administrator, is accused of infractions. It will not require three heads to see or discern those infractions if proved. Impaneling a three-judge bench for such a simple matter will be but a sheer waste of judicial resources. Judges in this country are a meager resource which should be equitably utilized. In this regard, I find the application to be without merit and I dismiss the same costs. Proceed. Very well drafted. This is closing a lot. And there are also submissions written, correct? Yes. All that we are doing is highlighting. So I don't expect you to take 1 hour to highlight the matters which are in the submissions.
No, my Lord, in fairness, and the reason why I'm asking that, the principal pleading is by the plaintiff.
For you, I think I am.
11th of January 2022. We have filed 2 other affidavits, my Lord. This is an affidavit in the first affidavit, plaintiff's father affidavit, sold by Lambert, which is in receivership, and subsequently there was an order saying it is also in administration. Mumias Sugar Company Limited.
I urge all councils to use the microphone.
Membership of Mumias Sugar Limited was the fact that it was indebted to a certain amount of money to KCB, the second defendant. An amount, according to our pleadings, that is about 2.7 billion shillings. This company, my Lord, owes a substantial amount of money to other entities, including farmers, including the government of Kenya and its various institutions, and other creditors.
A matter that is to be certified under Section 165 of the Constitution is one which raises substantial questions of law, which I see nothing substantial in this case, in that issue. The other issue is that the parties are bound by their pleadings. The seventh plaintiff has not filed a pleading to crystallize its claim against the defendants. Even if I was to consider the application by the seventh plaintiff as its pleading, nowhere in the motion nor the affidavit have the substantial questions of law particularized. The pleading is as plain as it could be. All the matters that were eloquently submitted on by Mr. Tate were not in the supporting affidavit. It was also submitted that the matter had attracted a lot of public interest. That may be so, but that alone cannot justify the impaneling of a three-judge matter, a three-judge bench. There are many cases that attract public interest in this country, and yet they are determined by a single judge. It was suggested that this court will be subjective in its determination of the matter, but the subjectivity arises from the fact that this court is the one that appointed the first defendant as administrator in the insolvency matter. This court tends to agree with the plaintiff for seeking the recusal of this court without necessarily saying so. I have relooked at the ruling of 19th November 2021. I do not think that these proceedings are a review or an appeal against the said ruling. Even if the party felt aggrieved by the said ruling, the best forum would have been to appeal to a higher court and challenge the same, not to come to a court of same jurisdiction or similar jurisdiction and seek to challenge the same. In any event, there is nothing on record to show that the said ruling is the one which is under attack or consideration. The seventh plaintiff questioned the manner in which this matter landed before this court. It is on record that the matter was first certified urgent by Okwani Jai when it was filed. She was proceeding on leave until mid-March 22. She then thought it wise to refer the matter to this court to give directions on the disposal of the same in view of the urgency involved. This court gave appropriate directions considering A, the first and sixth defendant alleged that the assets lying at the factory may be wasting. B, the plaintiffs, on the other hand, having set aside huge funds to undertake the running of Mumias, would like the imputed process undertaken by the first defendant set aside at the earliest so that they can put their funds to good use. Any further tampering with the Mumias by the sixth defendant would be extremely injurious to the plaintiffs. It is for the foregoing reasons that this court sustained the original urgency with a view to concluding the matter.